Hi. You look very glamorous today. Oh, you're on mute.
I put makeup on, that's why.
I've turned into Casper. I don't know what's going on. And I've moved my laptop. It's because I'm sitting in the window. I think it's just reflective.
It's tricky, isn't it? Because like where I sit, I'm behind the window, and if I've got that open, like when the sun moves between clouds, then like it affects the brightness of this screen. So I just shut the blind.
It's easier. Well, you've got people waiting.
Oh my gosh, keen people. Very keen. I'm just going to clean my screen. It's really dirty.
Okay.
But there may be a few more people coming to join us, but I know you'll all be eager to hear all about IR35, so we'll get going. So good morning everyone, and thank you for joining us for today's webinar all about IR35. For those who don't know me, my name's Joanna Sutton. I'm a Senior Associate Solicitor in the Employment Team here at Knockholds. And today we're going to be talking about the new IR35 rules that are due to come into force next month. Now, like many of you, I've been keeping a close eye on the news in the hope that perhaps these rules are going to be postponed again. We thought if there was any news, it would perhaps be announced in the budget, but unfortunately there was no mention of it at all. And all of the indications at the moment are that this is going ahead. So this is something, unfortunately, we now all have to get to grips with. So today's agenda, we'll be looking at what IR35 is, what does it mean, who it affects, and what you need to be doing to prepare. I'm going to be speaking for around half an hour, 40 minutes, something like that. We're due to have this webinar for an hour or so there should be plenty of time for questions, which I'll take at the end. If there's anything that springs to mind while I'm speaking, then please do feel free to pop your question in the chat box, and we can pick that up at the end. Or alternatively, you can just unmute yourself at the end and feel free to ask me anything that you like. We are recording today's webinar just to make you aware of that. So if we dive straight in, what is IR35? So many of you will be familiar with this, or at least with the term, but I'll start from the beginning. So IR35 is basically a tax rule which applies to try and catch people who are working on a self-employed basis but ought really for tax purposes to be classified as an employee. And it happens in this kind of structure that you'll see on the screen. So where you have a contractor working on a self-employed basis, but they're working through an intermediary who is the personal service company. So that's normally a limited company. It might be something as simple as, for example, Joanna Sutton Limited, and I'm then providing services to an end client. Now, sometimes that supply chain can be a lot more complicated with different agencies and things involved, but I'm just going to look at it in its simplest form in this kind of structure where you've got a self-employed contractor working through a limited company, providing services to an end client. So we'll bear that in mind. So it all comes about because in the 1999, the government announced a crackdown on individuals who were trying to avoid tax by working in this way. So by having themselves as putting an intermediary in the middle to mean that they could work on a self-employed basis, be paid by that intermediary, when really they ought to be working as an employee. And it's called IR35 basically because that was the name of the press release that announced this regime. So Inland Revenue, as it was at HMRC were at the time, and then the press release was number 35. And it's basically become the nickname of this tax regime ever since. But the official name for it is the off-payroll working rules. And when those rules came in, what the government were trying to do was to crack down on it and make the client responsible for making sure that the tax was paid in the correct way. But it was very unpopular at the time, and it was reversed really so that the intermediary or the individual contractor themselves remained responsible for assessing their tax status and paying tax in accordance with their correct employment status, which inevitably meant that most people just carried on treating themselves as self-employed and getting the tax benefits of working in that way and receiving dividends and things from their intermediary. So, as I say, what the purpose of the rules are is to ensure that people who are working as an employee, but calling themselves self-employed are taxed in the right way. So if you look, feel and smell like an employee, but you're calling yourself a self-employed contractor, what the rules are intended to do is to stop you from gaining the tax benefit that you have just by labelling yourself as self-employed, when really you should be being taxed as an employee. So it only applies when you have that structure that we saw on the slide a few moments ago. So where you've got the self-employed contractor, then the intermediary, and then the client. It doesn't apply for those just working on a completely self-employed basis as an individual, as a sole trader, and invoicing that client directly. It's only where you've got that intermediary in the middle that there is potentially IR35 considerations. So who's it going to apply to? So it will apply to an individual if you're a contractor and you're providing your services to an end client through an intermediary. It will apply if you're the client themselves who's receiving the services from the contractor through the intermediary. And it will also apply if you're an agency who might be another level in that supply chain, providing services from the contractor through their intermediary onto the client. As I say, I'm just going to concentrate on having that 3-tier structure just for simplicity. And I'm going to focus when I'm talking about today on the end client, because ultimately it's the client who's going to now have the liability under these IR35 rules. But I appreciate that many of you on the webinar today may be the contractor themselves, but what I'm saying is going to be relevant to you in understanding the new rules and how they will apply to your clients, so that when you're having discussions with them, you understand where they're coming from. But as I say, I can take questions at the end if there's anything that I haven't covered and you're a contractor and that you need to be sure about. So from the 6th of April this year, all medium or large size organisations, so the end client, will be responsible for assessing the employment status for the contractors who are providing services to them if they're doing it through the intermediary. So as I said, historically it's been the contractor or the intermediary's responsibility to make sure that the tax is paid and the correct employment status is applied, but that will no longer be the case, and from the 6th of April it's going to be that end client's responsibility. So you'll see that I've said it only applies to medium or large sized organisations. So many of you will be thinking, what does that mean? Am I a small organisation? Can I get out of it that way? So if you're a small organisation, these rules don't apply. They're only going to apply to medium or large sized organisations. Small organisations, the rules stay exactly the same as they are at the moment, so that it's the contractor or the intermediary's responsibility to deal with the tax in the normal way. So are you a small organisation? So this follows the same structure as the Companies Act rules. So a small organisation is if two of the following apply. So either your annual turnover is not more than 10.2 million, your balance sheet is not more than 5.1 million, and you've got less than 50 employees. So 2 of those have to be triggered to be classed as you have to be less than that to be classed as a small organisation. And you can't get out of it by sort of putting some kind of complicated group structure in place with lots of subsidiaries, because the rules say that for a group company to be classed as a small company for these rules, the parent company is the one that counts. So ultimately, that's what you're looking at. So if you're a small organisation under those rules, then don't have to worry about IR35, doesn't apply to you. But obviously your tax status or you meeting that criteria could change. So it's definitely something to be aware of what those rules are if you aren't hit by them at the moment. So what do you need to do? At its simplest, what you need to do is look at your supply chain. So you need to think about contractors who are working for you. Are they supplying their services through an intermediary? If they are, and you are not a small organisation, then you need to be thinking about these rules and making sure that you're complying with them. And basically what IR35 means is if you are engaging a contractor through an intermediary, you need to make sure that that contractor is genuinely self-employed. So you need to make sure that they are not actually working as an employee, and we'll look at some of the things that HMRC would be considering to see whether or not someone is genuinely self-employed. And you also need to think about it for any new contracts that are starting after the 6th of April. So that will affect obviously how much the contractor is being paid if they're going to be classed as employees, and then there's going to be further liabilities for you, which we'll go on to consider. So you need to think about anyone working for your organisation at the moment. on a contractor through an intermediary basis, and anyone who you might be engaging in the future. And you need to make sure that your your ears are pricking up when you're starting these new contracts, to make sure that you're going through the right steps for those new people that you're engaging. And what does it mean? So basically, if the contractor is found to be a deemed employee, so it means they're caught by the IR35 rules, so they're working on a self-employed basis, but as I said, they look, feel and smell like an employee, then you need to treat them as an employee for tax purposes. So that means you need to deduct income tax and national insurance from any monies that you're paying to them before that contractor is paid. You would also need to account for employer national insurance contributions and the apprenticeship levy if applicable. And basically what these rules mean is that you are now responsible, if you're the client, you're responsible for making sure that the right assessments are done and that you're paying the right tax and national insurance, and that they are. So you can't turn a blind eye anymore, as you might have done, where you might think, this guy is not self-employed, he's working as a normal employee, he's sitting next to Joe Bloggs doing exactly the same job as him, but we're just paying them on a different basis. But it's not my problem because it's his liability at the end of the day, so you turn a blind eye to it. You can't do that from the 6th of April because the liability is yours. So HMRC have said that they're not going to be looking at past compliance. So if you suddenly decided that that contractor who's been working for you for the last 10 years and you're now saying that that actually is an employee relationship for tax purposes and not self-employed, HMRC have said that they're not going to look back and try and unpick what's happened historically and come after you for, previous tax that should have been paid if the correct employment status had been applied. They're going to focus on compliance going forward. So the only time that they've said that they're going to be looking into the previous arrangements is if there's fraud or criminal behaviour, but in the main, they're just going to be looking forward. And one of the main indications I think that we've got that they're probably not going to postpone this again. So these rules were due to come into force on the 6th of April last year, and at last minute it was announced that they wouldn't be coming into force because at that time we were really in the grips of the early stages of dealing with the pandemic, and so it was postponed until 6th of April this year. And as I said, many of us have been eagerly awaiting to see if there's going to be a further delay. But what HMRC have said is that they're not going to actually enforce penalties for compliance for this for the first 12 months, unless, again, there's deliberate evidence of non-compliance. So, you've really gone out of your way to avoid it. So there's sort of a 12-month bedding in period. And I think that that's probably quite a key indication that these rules are coming and we do need to deal with them. But there's a little bit of breathing space to get your head around them. But, still need to make sure that you're taking steps to comply. You can't just completely ignore them for that first 12 months. So as I said, basically IR35 is all about employment status. It is looking at whether someone is genuinely self-employed or whether they should actually be classed as an employee. And as we know, that all comes down to actually what's happening. So you might have a really elaborate contract that says all kinds of things that try and make it look like you're self-employed. The contract might say that you're self-employed and that your contractor is responsible for their own tax and national insurance and all that kind of stuff. But what actually matters is what's happening on a day-to-day basis. And for IR35 purposes, nothing has changed, in the assessment of whether someone is genuinely an employee or self-employed. Those tests remain exactly the same. So I'll take you through some of the things that HMRC would be looking at. So the first one is to look at mutuality of obligation. So that basically means, is there an obligation on you to offer that person work? And if you do, are they required to accept it? So if you compare that to an employment situation where you have an employee, you give them work, you have to pay them, they have to take the work, and there's mutuality of obligation there. In a self-employed relationship, that wouldn't necessarily be quite the same. So you might offer work to a self-employed contractor and they have the right to turn it down and say, no, I can't do that job because I'm working up the road that day. And then there's no obligation on you to offer it or for them to accept it. So mutuality of obligation is quite a key indication of a genuine self-employed relationship. The next one to look at is personal service and substitution. So in an employment situation, you're employing that person because you want them to be doing the work. You only want that person. Whereas in a self-employed situation, you might just want the work done, and it doesn't necessarily matter who does it. So in a genuinely self-employed situation, you may have a substitution clause in an agreement with a contractor where it says that that person might provide the work, or they might be able to send someone else to do it on their behalf. And so again, that difference between one person having to perform the work and not having the option to sub in someone else, or the ability to switch stuff around and get someone else in to do the work for you under substitution, is quite a key indication of that being a self-employed relationship and not an employee relationship. Next one to think about is control. So how much control is the individual under? So again, if you think about an employee, you're telling them how they do the work and what process to follow and where you want to do it and how they've got to do it. Whereas in a self-employed relationship, there might be a bit more flexibility. So they might have the ability to set their own hours, for example, or they might decide where they're going to be able to perform the work or how they're going to do it. They might have their own processes that they're going to put in place. So it comes down to looking at how much control are you exercising over the individual that's doing that work for you. The more control there is, the more likely that they're going to be an employee rather than a genuinely self-employed contractor. Another consideration is, can they work elsewhere? So again, in an employment situation, it would be unusual for an employee to be able to work for another organisation, particularly if they're working on a full-time basis. Whereas in a self-employed situation, you would quite often have different jobs going on in different places, and you might work a few hours in one place and a couple of days somewhere else, and that would be much more common under a self-employed relationship. And then you look at whether there's control over the individual being able to do that. So do they have to ask you permission? Are there restrictions on working for a competitor? That kind of thing. And again, the more control there is over the individual, the more likely it's pointing to them being an employee rather than a self-employed person. Now, obviously, from a commercial point of view, there's going to need to be restrictions on what an individual can do while they're working for your business. So even in a self-employed situation, you're not going to want someone coming into your organisation and doing work and having access to all of your information and customer database and things like that, and then being able to just trot down the road and share it with somebody else. So there can be restrictions, but this is something to be aware of when you're making agreements with people, to keep these kind of things in mind as to whether they are going to be seen as an employee or a self-employed person. Other things to consider are how integrated they are into your organisation. So what would they look like to a client or a third party? Would they look like they're a contractor that's working for themselves but providing services to your organisation, or would they look like they're an employee? Do they have the ability to hire and fire staff, for example? Are they doing appraisals for your team? All of these kind of things, if they're doing that sort of thing, they're much more likely to be an employee rather than a self-employed contractor who's providing services to your organisation. They're much more likely to be seen to be integrated into the organisation and then more like an employee. Another consideration is who provides the equipment. So again, in a self-employed arrangement, it might be more common for the individual to be providing their own equipment. But again, that may not always be possible. So you might have somebody who is providing contractor services to do with IT or something like that. And you wouldn't necessarily want them to be using their own equipment to provide those services, because you need them to be using your software and your systems and that kind of thing. So again, it's not a one size fits all, but these are the kind of considerations that there will be. So looking at who provides the equipment, that's another potential indicator. Financial risk, that's a key indication of being self-employed. So you might, for example, have an agreement where the contractor is only paid on completion of a project or the piece of work that they're doing, rather than being paid on a regular monthly basis, on a day rate or something like that. You would look at things like, if there's a problem with their work, do they have to put it right at their own cost, or are you going to carry on paying them while they correct that in the normal way, which would be much more like you would see in an employee situation. Another consideration is notice period. So with an employment relationship, obviously you're normally going to have a notice period so that if they leave, you've got time to look for a replacement. With a self-employed contractor, again, you would probably want that from a commercial point of view so that they couldn't just leave you high and dry if they didn't want to do the work or they got a better offer down the road. But the longer the notice period, the more likely it is that they'll probably be more like an employee rather than a self-employed contractor. And then another indication is the provision of benefits. So if you are a self-employed person, you would not normally be receiving gym membership or private health and that kind of thing that an employee would. So again, thinking about those kind of things, are you paying expenses? All of those kind of things that normally would make you think of an employee are best to be avoided if you want it to be seen as a sort of genuinely self-employed arrangement. So HMRC have created this new tool that you can use called the Check on Employment Status for Tax tool, so CEST for short. And that is designed to help individuals and contractors decide if they should be classed as an employee or should be self-employed for tax purposes. It's quite useful because HMRC have said that they'll stand by the result that's given by the tool, so that when you are having to do this assessment to determine whether or not the person that's working for you is genuinely self-employed or not, if you have used this tool and you've genuinely answered the questions and it said, no, they are genuinely self-employed, HMRC have said that they'll stand by that result. They're not going to, to look into that any further. So, the main thing, if you're going to use it, is not to pick your answers to their questions to make it look like you want a certain result from it. So you can't, for example, say, yes, there's a right to substitution when there isn't, or, you've never exercised that right. So you have to be careful about how you're answering the questions. But if you're answering them genuinely and HMRC give a result that say you're not caught by the IR35 rules, the contractor is genuinely self-employed, then that can be really useful. And so that's what many people are using because it's HMRC's own tool. You can't get better than that to do this status determination to work out whether this contractor that you're engaging is genuinely self-employed or not. So have a look at that. You can obviously save and print the decision for your records and produce that to HMRC if they ever did look into the arrangement. And it's quite useful. You could have a look at it now. There's no need to put in your details. There's no record kept. It's completely anonymous, so it's not going to sort of trigger HMRC looking into you if you do use that tool. So definitely check that out if you haven't already. So the CEST tool looks at many of those things that I've just spoken about, the employment indicators. So the questions look at, is there a right to appoint a substitute? Do you have to agree to it? Have you got the right to insist that they've got particular qualifications and things like that? Looks at the control that you can exercise over the individual about how they're performing their tasks and where they do it and when and all the rest of it. It looks at who provides the equipment, who pays for expenses, how are you paying the contractor? Are you paying them a day rate or an hourly rate? Are they being paid on completion of the project? Have they got that financial risk? So about putting the work right, who pays for that? Are they entitled to any corporate benefits? How integrated are they? Do they have management responsibility for hiring and firing? How would a third party look at them? Can they work elsewhere? Is this just a regular series of contracts? Which, again, if you're employed for a long time with an organisation or you're working on a self-employed basis, year after year after year, perhaps that would be more of an indication that you're a genuine employee rather than self-employed. And how much work does the contractor spend, dealing with this? Are they working elsewhere? So these are the kind of things that the CEST tool looks at, which, as you can see, links directly back to those employment status indicators that I've spoken about. And, as I've said, nothing has changed in terms of employment status. It remains exactly as it always has. You're an employee or you're self-employed, and none of the rules have changed around that. So this is really just looking at the correct categorization of the person working for you and whether you've given them the right label. And if you haven't, now's the time to make sure that you are. So what does it mean if you're outside of IR35? So you're not caught by the rules. So that's what you want, ideally. That's when somebody is found to be genuinely self-employed. And in those situations, even if you're a medium or large sized organisation, you can carry on contracting with the intermediary and the end contractor in exactly the same way. They're the ones that remain responsible for the tax and national insurance, not you. So nothing changes. That's the best result for going through this. So ideally, you want to be outside of IR35, so you're not caught by the rules and you just continue as normal. So that's what we're all aiming for. But if you're inside IR35, what does that mean? So that means basically that you need to treat that contractor as an employee for tax purposes. So you need to deduct tax and national insurance before you pay them, and you also need to pay employer national insurance as well. Importantly, it doesn't mean that they suddenly become an employee. This is literally just for tax purposes. So it doesn't mean that they gain employment rights. You've not suddenly got to start paying them holiday or sick pay or anything like that. That still remains the arrangement between them and their intermediary. Now, most people are working for the intermediary on a self-employed basis, so they don't have any of those entitlements at all anyway. But this is literally just looking at making sure that the right amount of tax is paid because you're labelling the employment status correctly. So it only affects your status for tax, not your employment rights and what you have to provide to that contractor. So what you might need to do is to renegotiate those contracts, because there's going to be an additional cost to you if you're suddenly having to pay employer national insurance contributions. So you might need to look at actually renegotiating the amount that the contractor is being paid. You might consider as an alternative getting them to work through an umbrella company. They would be an employee for those purposes, but the employer would be the umbrella company. So it's sort of creates an additional layer between you and the contractor. It's probably going to be unpopular for the contractor. They probably won't want to do that, but it's one way of avoiding, you getting involved in any of the liability at all by having that additional layer in place. And then it's the umbrella company who has the liability. You still need to make sure you're assessing the status correctly, so you can't just get out of it altogether. But if then the umbrella company is engaging the contractor as an employee, they're taking responsibility for all of the tax and national insurance, then that's another option for you. Or you could consider actually just putting the contractor on your books as an employee. That might be something that you want to do to keep that individual. They may not like it very much because it's going to affect obviously the amount that they're paid, and you need to be careful not to be bringing them in as an employee, still paying them their self-employed rate, and actually that's more than the employee that they're sitting next to doing exactly the same job. So you need to be careful, and you also need to be careful because obviously bringing them on as an employee, they're going to gain employment rights, so they're going to have the right to unfair dismissal claims and redundancy pay and stuff like that if they work for you for over 2 years. So one option is to give them a fixed term contract for less than 2 years, and then you avoid those kind of rights, but you're still obviously going to have to pay things like holiday and sick pay, pension, maternity. So again, that might not be something that you necessarily want to do. But basically, if you're inside IR35, you need to treat that person as an employee for tax purposes. Now, it's possible that those contractors who you suddenly say, actually, we think you're an employee and we're going to start taxing you on that basis, as I said, wouldn't be very happy about it. And they might try and say, well, actually, if I'm an employee, then I want you to start paying me all the holiday pay that you haven't paid me for the last 5 years, or, the sick pay for that time off I had last week. As I said, it doesn't mean if you assess them as being, inside IR35, doesn't mean that they gain all of these employment rights unless you decide to bring them onto your books as an employee. But it may be that they start trying to assert certain rights about that. But obviously they've had the tax benefit of working on a self-employed basis for all of this time. So if they suddenly start saying, I want to be treated as an employee, then they'd have to be accounting for the tax that they should have paid as an employee. So that may hopefully make it less likely that they're going to raise issues about that. One other thing that you need to do from the 6th of April is to make sure that you have a client disagreement process in place. So basically like an appeal system, so that once you've assessed that contractor's employment status and you've said to them, I think you're within IR35 or you're outside of IR35, that they have the right to challenge that decision. So obviously you're probably only going to get people challenge it when you say that they're inside IR35 and you're going to start taxing them. But you need to have this appeal process in place, which basically says that they need to have the ability to raise a dispute with you about how you've assessed them, and so to complain that actually, you know, there was a substitution and they did use it once, and so you should take that into consideration, for example. And you need to respond to any disagreement that you receive within 45 days. And during that period, it doesn't mean that you can just revert to treating them as a self-employed person because that's what they want. If you've said they're inside IR35 and that's what they're complaining about, then you need to make sure that you're continuing to apply the rules in line with your original decision. So if you've said they're inside IR35, you need to carry on taxing them, doing the NI deductions as if they were an employee until you have reached your decision. So at the end of it, you can decide you still uphold your decision that they're within it, IR35, or they might say something that makes you change your assessment, in which case, if you say they're outside of IR35, from that point on, you can treat them as a self-employed contractor. It doesn't mean you need to change anything for those 45 days that you've been reassessing your decision. So basically make sure that you've got some kind of process in place. It doesn't need to be, you know, sort of a great long policy like you would have perhaps for a disciplinary or, you know, grievance policy, but just to make sure that the contractor is aware when you tell them what your assessment is, that they have the right to challenge that if they want to, and how they should do that. So sending an email to you or something like that, setting out what the reasons for their disagreement are. So that needs to be in place from the 6th of April when the rules come into force. So the question that all of you will be have on your lips is, how can I get out of this? How can I avoid IR35? Well, obviously we as a lawyer, we can't say that there is any surefire way of avoiding IR35, but there are things that you can do to limit the risk of it applying, and that is basically to make sure that if you're using a self-employed contractor working through an intermediary, that they are working on a genuinely self-employed basis. So looking at your contracts that you've got in place with that individual and making sure that there's contract in place is definitely the starting point. So often, it's particularly if you've had sort of long-standing arrangements with contractors, it may be that there's no agreement in place and it's all worked very well, but then that causes more complication, as you'll know, because it then comes down to assessing exactly what's happening on the ground. So having a good contract in place is really the starting point for all of this. And so in the contract, you want to include, if possible, that right of substitution, because that helps point away from the personal service, the fact that you're not engaging that person as an individual to provide the services. You just want the work done, and it could be done by anyone. If that works for your business, you know, great. As I said, it may not work in every situation, but if you can include a right of substitution, that's really helpful in pointing away from, you know, it being an employment relationship. Avoid that obligation to provide and accept work, so you can expressly state that you know you're engaging them to provide this service, but you don't have to give them work, they don't have to accept it. That's again really key to pointing away from it being an employment relationship. Avoid a notice period for the reasons that I've said already, that you know a longer notice period would be more like an employment relationship. Make sure that when they're actually working, they're subject to as little control as possible. So as I've said, you can put whatever you want in a contract, but it really comes down to what's happening on a day-to-day basis. So you need to make sure that the contracts are actually reflecting the reality of the situation. So when they're performing their services, they need to be subject to as little control as possible. So they need to be free to, you know, do their own hours if possible and decide how the work's done, that kind of thing. So think about if there's anything you can introduce to make that more like a self-employed relationship. You could consider structuring the contract so that it is in accordance with the completion of the project or a particular piece of work, rather than an open-ended, you know, we're engaging you to provide these services, there's no end date, there's no fixed term. If you structure it to completion of a particular project, then again, that's more like a self-employed relationship rather than an employee who's just engaged on a daily basis, you know, with no end in sight. And then you can structure the payment by reference to the completion of the project, so that you're not just paying invoices that are submitted on a monthly basis or something like that. So you pay them when the project is actually completed, so that then there's an element of financial risk for the contractor, which again points to them being self-employed rather than an employee. And you could have, you know, for example, that they take a financial hit if the work's late, or, you know, you give them some kind of incentive to finish the work early, something like that, so that there is, you know, it's not a straightforward, you're working X amount of hours per week, paid at a rate of X, and, you know, they get paid no matter what. So having that kind of financial risk in place is really useful. Don't make them subject to your policies. There may be some policies that, you know, you want to make sure that they're subject to, so stuff like tax evasion or bribery, but you wouldn't necessarily want them to be subject to all of them. So you couldn't, you know, have them under your disciplinary policy and things like that. So the less that you can, the more you can do to make them less integrated into your business, the better. Definitely don't offer them employee benefits, don't give them gym membership, don't offer them private medical, things like that. When you're self-employed, that's your responsibility to pay for, so don't give them employee benefits. You could think about getting them to provide their own equipment if possible, so that can, you know, that can help to point to them being self-employed. But as I said, it might not work if they're, you know, doing a job where they need to use your systems or something like that, and you want to sort of restrict their access to that, and obviously state in the contract that what the intention of the parties are about the employment relationships, and the fact that they're engaged on a self-employed basis, they're responsible for their own tax and national insurance, that this is not an employment situation. You know, that can all be really useful, but as I said, the main thing is what's happening on a day-to-day basis. So starting point, look at the contracts, but actually look at what the individual is doing on a day-to-day basis to determine whether or not they are actually caught by IR35. And the most risk-averse approach is just don't engage anyone working through an intermediary on a self-employed basis at all. That's the approach that these rules came in the public sector in 2017, and that's the approach that many in the public sector took, that it just wasn't worth the risk, and they just didn't want to get involved in all of this, so they just said, we're just not engaging people on that basis at all anymore. You can be an employee, or, you know, that's it. The risk of doing that is obviously that you could lose really great talent, people that have been working for your organisation that you know you really need and you really value, and your competitors might not take the same approach, so that individual might then just trot off up the road and go and work for someone else, and you lose them. So that is one option, to just say we're not working on that basis anymore, but it's not necessarily going to be right for everyone, and there's a risk, as I say, of you know, that impacting on your business, which you won't want to do. So quick summary then before we move on to questions. So these are obviously a major change because they shift the liability to the client, rather than being able to just not really think about what someone's proper employment status is, because it's not someone else's problem anymore, it's your problem, unfortunately. You need to think about the contractors that are providing services to you at the moment, or that might come along in the future. You need to assess their status to determine whether or not they are genuinely self-employed or employees. You need to make sure that you're updating your contracts and your processes accordingly. So doing it now and doing it for people that might start working for you in the future. And you should bear in mind that HMRC are obviously introducing these rules to make money, and they're anticipating that they're going to get a lot more tax as a result. So you need to make sure that you're doing these assessments properly, to avoid them, you know, coming after you for trying to, you know, look into these arrangements further, because they obviously think they're going to make a lot of money out of doing this. So make sure you're looking at everyone working for you. You don't need to worry about those ones that are just working on a sole trader, self-employed basis, invoicing you directly. It is only those ones that are working through an intermediary, their limited company in the middle. Look at the contracts that are in place, update them, renegotiate them if necessary, and make sure that they reflect actually what's happening. You could consider terminating them if necessary, or putting them as an employment, putting them on the books as an employee. And most importantly, as with anything employment law related, make sure that you're keeping records. So keep a copy of that CEST assessment if you're using the HMRC tool. You know, keep a record of why you have answered a certain question if it could be potentially ambiguous. So, you know, why you said there is a right to substitution and that it was exercised in 2015 or something like that. Just to back up what you're saying, because, you know, HMRC can look into this years down the line. So keeping records and having a record of why you made a particular decision is really important. So that is IR35 in a nutshell. I've whizzed through it, and I am not sure if anyone has questions that they want to ask, or if we've had any through, or if I've just bamboozled you all.
Hello. Hi. I've got a quick question. So if your turnover is under 10 million, and you sort of tick those boxes, does that mean we don't have to worry about it? If we've got less than 50 employees and our turnover is less than 10 million, we don't need to worry.
Yeah, if you meet at least 2 of those criteria, so you've got less than the turnover in the balance sheet and less than the 50 employees, you will be a small organisation, so you don't need to worry about it. It's only the medium or large size ones at the moment. But obviously bear in mind that, you know, over time that might change and you might take it to the next category. So it's something to be aware of. But yeah, if you're lucky enough to fall into that, then you don't need to worry at the moment.
Thank you.
Hi.
Hi.
Hi, we've got a quite unusual situation. We manage, I mean, we're under the 10 million, but theoretically, yes, we don't have more than 50 employees because they're self-employed. So, but it's complicated because we run a security company, and security guards have been employed for a number of years now. That changed a long time ago, but we specialize in security dog handlers. Now, dog handlers bring their own tools of the trade, etc. And we've been advised by our governing body, which is the Security Institute, that HMRC have stated that they do come under IR35, where I've carried out CEST tools several times, and so have the dog handlers, and it does actually come up that they're not, that they don't fall under IR35. So we're in a complicated situation where we don't really know where we stand.
Sure. So it sounds like if you've got more than 50 employees and some of them are self-employed, then they can be caught by this, because you need to do that employment status test to check whether or not.
Which we have, and it still comes up as self-employed, although our ombudsman has been told by HMRC that they do fall within IR35. But like I said, they can refuse work. They can provide a substitute. They do provide their own tools of the trade. We're not the end user, where we are an intermediary in essence, because obviously it's our clients and then we use the security dog handlers. But it's nigh on impossible to employ them because there's not long-term contracts. It's ad hoc. All the work is ad hoc. And I understand there's 0-hour contract scenarios as well. However, with their own tools of the trade, etc., that they bring on board, you cannot employ them because the overhead costs for them personally would be massive.
Yeah, it sounds like, you know, you've done the right thing because you've done the CEST assessment, and I think that's what you need to do under IR35. So whether HMRC are saying, you know, they can't say they are all caught by it because they don't know the individual working arrangements. So I think what you've done is right, that you do the CEST assessment, you keep a record of it, you make your decision based on that, and then, you know, if HMRC come and, you know, ask questions about it, you explain all of these things that point towards them being self-employed, like they provide their own equipment and their short-term contracts and it's ad hoc and all the rest of it, those things that, you know.
I mean, we meet all 3 of those criteria in essence, to fall outside of it, under 10 million, etc. Obviously our clients don't fall under that because they are larger organizations, so whether or not it cascades down from them to us,
it does.
They may say to us we have to employ them.
Well, not necessarily. They just want to make sure that the assessment is
we meet the assessment criteria.
Yeah.
So theoretically, my CEST tool assessments and our ways of working, I need to just justify and evidence it to my clients, to the end user.
Yeah, absolutely. Yeah.
Okay. All right. That's more definitive than what I've heard so far over the last year. I've been trying to find out.
Oh, good. That's useful.
Thank you.
Any other questions?
Hi, one from me, Lynn Smith. Does IR35 apply where the contractor is actually resident in a country outside of the UK, but it's the UK company that is engaging them?
I think it would still apply because it's the UK company who has the end responsibility to assess the status. But if they're working outside of the UK, then are you paying them subject to UK rules, or are they're dealing with it all themselves?
They're dealing within themselves.
Yeah, I think you still have to do the assessment, but it's unlikely that they would be caught by it.
Right. Okay. Thank you.
Any other questions? I don't think we've had anything come through on the chat. Obviously, if no one, if you don't want to jump on video and ask it, my details are on the screen there. So please, do feel free to give me a call or drop me an email. I'm happy to help answer any questions. And obviously once you start doing these assessments or you're looking at contracts and things like that, then, give me a shout and I can help with any of the tricky issues that might be popping up. No more? Okay, great. Well, I hope that you found today useful. I tried to keep it short and sweet because it's a tricky topic, and no one likes talking about tax at the best of times. I hope that you found it useful. We do these webinars quite frequently on new topics that crop up. So if you're not already signed up to our mailing list, then please do. And we also deliver in-house training as well. So if there's a particular topic that you think it would be useful for us to come in and speak to your staff about, then I'm quite happy to do that as well. So just remains to say thanks very much for coming along, and please do get in touch if there's any queries that I can help with.
Thank you.
Thank you.
Welcome.
Thank you so much.
You're welcome.